So you've been arrested and charged by the police for a crime. What's the next step? Well, you must appear in court to formally face that charge during what's called an arraignment. Now, as for what that is, noted criminal defense attorney Craig Butler explains.
You cannot keep a person in police custody, of course, beyond the 48 hours without extensions, and you cannot continue to keep somebody unless you charge them. So they're brought before the magistrate's court, and depending upon the level of the charge, they're either asked to plead guilty or a date is set for preliminary inquiry. It is important to do that so that the person is turned over from the police custody and basically put in the custody of the courts.
Now, once you've been arraigned, the prosecution must decide how to proceed with the case. And according to Mr. Butler, there are two options. One, by way of a preliminary inquiry, also known as a PI, or a voluntary bill of indictment, also known as a VBI.
Well, a preliminary inquiry is the same person, that magistrate, but the magistrate wears a different hat. So when the magistrate sits, he or she is a presiding justice, and that means that they will hear the case from the prosecution, and it is then up to them to decide whether or not sufficient evidence has been put forward by the prosecution to cause that person to go up to the Supreme Court, where a trial will be held with a jury. And what a voluntary bill of indictment is that it is a device that can be used by the Office of the Attorney General when they feel that the case is so strong, or when they feel that the preliminary inquiry is not necessary. They will go and they will enter documents and they will say that this is a case that is suitable to go straight to the Supreme Court.
So essentially, a PI works in the favor of the defense, and you guessed it, for the prosecution, a VBI is the way to go.
The VBI is definitely advantageous to the Attorney General's office. And mind you, everybody who goes to the Supreme Court is not guilty. We tend to think around here because somebody's charged in front of the court and somebody's up there, well, they must be guilty. If you can save the taxpayers' money, and if through the examining justices it's decided, no, there's not a case to answer, well, it ends there. And going to the Supreme Court is an expensive ordeal these days. It's not cheap. Defense attorneys, although many people in the public would like to think that we work for free, we don't work for free. And so when you do go to the Supreme Court, it's an extremely time-consuming thing. And you charge on a daily basis, and those charges can really add up. So if the charges can be had away at the preliminary inquiry stage, you can save that family potentially a lot of money.
Until next week, I'm Sasha Lightbourne, and now you know your rights.